Let's start. This revisional application is directed against order number 41 dated January 11, 2013 passed by the Landed Civil Judge within bracket Junior Division Additional Court shall the entitled suit number 7 of 2012 by which an application under order 7 rule 11 of the Code of Civil Procedure is rejected. Para. The plaintiff of the opposite party filed a suit for recovery of possession from the suit land upon determination of tenancy under the provisions of Transfer of Property Act. Para. The defendant of the petitioner, however, entered appearance by filing a written statement in order to contest the said suit. Para. Subsequently, an application under Order 7, Rule 11 of the Code is taken out by the defendant of the petitioner praying for rejection of the plaintiff. The said application contains as many as 4 paragraphs. Para. Paragraph 1, which is most relevant for the present purposes, contains the averment that the suit has been filed for recovery of the vacant piece of land and therefore the property is governed by Kolkata Tenancy within bracket Acquisition and Regulation Act 1981. Paragraph is consequential to the statements made in paragraph 1. In paragraph 3 of the said application of the defendant of the petitioner says that the court lacks jurisdiction to entertain the said suit because of the embargo created by law, and paragraph 4 relates to the relief in the said application. Apart from there is no other grounds taken for the purpose of rejection of the plaintiff under Order 7 Rule 11 within bracket small d of the Code of Civil Procedure. Learned advocate appearing for the defendant of the petitioner audaciously submits that apart from the said ground, there are other grounds on which the plaintiff should be rejected. I am afraid that the point which was not agitated before the trial court nor incorporated in an application under Order 7 Rule 11 of the Code should be allowed to be taken before the revision court for the first time. The second limb of submission of the learned advocate appearing for the defendant of the petitioner is that the impugned order suffers for want of reasons. The trial court, while rejecting the said application under Order 7 Rule 11 of the Code, has not assigned any reason. This court is not oblivion of the fact that the court is required to assign the reasons either allowing the application or rejecting the same. The revisional court before which the order is brought, if ultimately founds that the conclusion which has been arrived by the trial court is correct, the revisional court can certainly supply the reasons. Let me now proceed to deal with the said point which has been agitated in the said application under Order 7 Rule 11 of the Code. The suit was filed for recovery of possession of a bare land upon determination of the lease by issuing a notice under Section 106 of the Transfer of Property Act. The determination of the tenancy under Section 106 of the said Act is one of the ground for determination of lease as would be envisaged under Section 111 of the said Act. It is unthinkable and inconceivable that such a suit would come within the ambit of Kolkata Tenancy and lands within the Acquisition and Regulation Act 1981 of West Bengal Tenancy within the Acquisition and Regulation Act 2001. The very definition assigned in the above act relating to the tenant purpose is the existence of a structure. It is a settled law that the court, while considering an application under Order 7 Rule 11 of the Code, shall not look into any other material than the averments made in the plaintiff. My endeavor has failed to find out any ground which would come within the ambit of Order 7 Rule 11 of the Code on meaningful reading of the averments made in the plaintiff. The strange argument is sought to be made that the relationship between the tenant and Bharatiya shall be governed by West Bengal Premises Tenancy Act, so the suit under the Transfer of Property Act is not maintainable. I am not at all impressed by the said submission, as the suit is instituted under the provision of Transfer of Property Act for recovery of possession of a bare land land which neither comes within the purview of Calcutta Thika Tenancy within bracket Acquisition and Regulation Act 1981, nor under the provision of West Bengal Premises Tenancy Act, which applies to the tenancy of the premises. The definition thereof envisages the existence of the building pair. From the length and breadth of the said plaint, I do not find that there is any claim in respect of the structure being made therein. Even the schedule appended to the plaint relates to land for which the recovery is sought. Therefore, this court finds that the application under Order 7, Rule 11 of the Code is misconceived and has been made to delay the carriage of the suit. Such a frivolous application deserves dismissal, as has been done by the trial court, but with exemplary costs. The trial court, as it appears, shown the sympathetic approach in not awarding the costs which this court cannot concur with. Needless to mention that the observation made herein above is restricted to the disposal of an application under Order 7, Rule 11 of the Code, and is mere tentative in nature and shall not have any persuasive effect upon the trial court at the time of final disposal of the suit. The trial court is requested to make all efforts to dispose of the suit as expeditiously as possible without granting unnecessary adjournment to either of the parties, preferably within 6 months from the date of communication of this order. The divisional application is dismissed with cost assessed at 50 GM to be paid by the petitioner to the learned advocate appearing for the plaintiff or the opposite party in this court within a week from a date. Urgent photostat certified copy of this order be supplied to the parties if applied for on priority basis. Stop. Thank you. Jai Hind. Jai Mera Bharat.